This is Ann Babiarz, and today I am going to interview my better half, my husband Michael, who retired several years ago from practice as a lawyer. He is a graduate of John Marshall Law School, where he attended on a full academic scholarship. Michael then served as a law clerk to the Honorable Howard C. Ryan on the Illinois Supreme Court before beginning a career as an estate planning, elder law, and asset protection attorney as the owner of his own law firm. He was the chair of the American Bar Association Committee on Elder Law, won awards for service to several nonprofit organizations, and taught as an adjunct professor at Harvard College, and also taught continuing education courses. And in interviewing you today, Michael, I want to pick your brain on asset protection, particularly for these tough times and beyond.
Well, I guess if the listeners are anything like me, they kind of want some comfort, maybe a little less fear in their lives right now.
Absolutely.
And unfortunately, right now, some folks are working through some fears, but it doesn't have to be that way. In my humble opinion, there's really no reason to be stockpiling toilet paper, pulling cash out of the bank, or heading for the hills to hide.
Yes, I know. I've heard lots and seen lots of concerns about those very issues.
Yeah, and I'm not going to tell people here how to be prepper heads or anything like that. This is for people who really kind of like their urban and suburban life and you just want some direction perhaps. Again, this is in my opinion. It's not the fault of anybody to be scared, but maybe we should just look at some things that might help.
Well, and that is absolutely true. There are so many people that just don't really understand who to listen to in these times, and it can cause them to panic. So what can you pull out from your old toolkit when you used to do asset protection planning for your clients?
Well, let me look at it this way. I think I can think of 3 things that you could look at that might help. And then if we have time, some cautionary notes too.
Well, okay, so let's jump in.
Well, okay. The first thing I think everybody needs to have in place, again, in my opinion, when we're looking at a situation, whether it's something like this, whether there's something traumatic going on in our society, or really at any time, in order to be properly prepared for something, is to look and be sure that you have in place a medical power of attorney. This can be called medical POA, medical power of attorney, healthcare power of attorney. It goes by a number of different names. And most states have suggested formats for these documents. They're paper documents. They're created, you sign them. They usually have some form of witnessing requirement. I know for our listeners in Illinois and Wisconsin here on the broadcast show that both Illinois and Wisconsin do have suggested forms that their legislatures put into their statutes.
What would you say about that? As far as I know, people can go on different websites and things and get those forms, but what would you say would be the most important thing for them to know at this point?
Well, a couple things. First of all, you always want to check within your existing documents. If you've been to your estate planning attorney, he or she probably recommended and perhaps drafted some of these documents for you already. If you don't have an estate plan, I guess I'll say shame on you.
Well, and you know, isn't that the number one thing in America that people don't have?
Yeah. 70% of all Americans don't do anything. But if you're one of the 30% that did, bravo. And your attorney probably already discussed this with you. But okay, if you're in the 70% that didn't, again, not to fear. The states usually have some suggested form. And yeah, you can usually find these things online. what I would suggest is let's look at it from a couple different points of view. First of all, I would suspect that many attorneys nowadays in this current time are acting like many businesses, and that is, if you don't want to come to the office, we can probably do some things over the phone and online. So the first suggestion is if you already have a professional, call her, and you don't have a healthcare power of attorney, can say, hey, can we work this out? Can you consult with me over the phone? We get this thing taken care of, and I can get it put in place, in a reasonable period of time.
But what about witnesses and so forth?
Well, again, most states have some form of witnessing requirement, and typically, as long as it's not someone related to you, you can find a neighbor. Yeah, we're going to have a social distancing issue here, perhaps. But, I guess if you still wanted to stay 6 feet away from each other, they could be, outside on your front porch or on the other side of a room. And as long as you say, hey, I'm signing this right now, and you sign it, and then you walk away and they walk up to it with their own pen, sign it, and leave with their own pen in hand, I think we've met the goal of social distancing.
What about notarization?
The medical one, in some states, it doesn't need a notary.
Okay.
So you'll have to check. If you need a notary, same thing. Sometimes some of them will make house calls. Do you need to get to your local bank or something like that to do it? If you have to, you have to. But oftentimes the medical or the healthcare powers don't need them. So the first step, again, is call your lawyer if you have a relationship with one and say, can we do this where I don't have to come to your office? I want to get this squared away.
What about doing an estate plan on a napkin?
Well, I wouldn't suggest, let's take the one piece we're talking about now, the medical
right.
POA.
I'm sorry, I didn't mean to jump ahead on you.
That's okay, no problems. We love your ambition. I used to love clients like you. You need to look at the medical power of attorney form, and most states will say you can do your own document as long as it meets our requirements, and the requirements are things like witnessing, signature, dating, things like that. However, I usually, when I was in practice, my opinion was, and it will be my humble opinion now as I'm just teaching this and no longer giving legal advice, but is to consider sticking close to the statutory form. Because if you need health care assistance and you're going into a hospital, you're going to a medical provider, they're required under federal law to ask if you have one of these documents. They can't force you to have one, but they're required to ask.
Got it. Because I know I've seen on some different social media sites that it's okay to just write it down and that would be your estate plan. And I think that's it's
a little irresponsible.
That's very irresponsible.
Yes.
Exactly.
So when we're looking at this first piece, and we'll talk about another piece here in a little bit, but stick close to the statutory form. See your attorney if you can. If you don't have one and you can find the statutory form for your state online, it's, even a retired attorney always hates to tell people it's a do-it-yourself deal. I don't think it is. But if you're up against it and you have no choice, trying to do one yourself from some online form is certainly better than nothing. And again,
Gotcha.
Stick close to the statutory form. Make sure you meet the witnessing requirements, the dating requirements. You've signed it. And the reason you don't want to stray, again, in my opinion, from the statutory form is, again, if it's necessary, if you're admitted somewhere or you're going somewhere for medical treatment and you provide a copy of that, if it's one that's the statutory form in your state, the hospital or the doctor or the staff or whatever are going to say, great, we've seen thousands of these, we know exactly what this is, and we'll scan it and put it in your file. If you come in with something you drafted on a napkin and that's maybe it's witnessed and signed and everything, but they're going to look at it and go, oh, maybe we'll have corporate counsel look at this. And that may delay the ability for whoever you've named under the medical power of attorney to act.
So a napkin, you should probably be using that more for toilet paper these days
Yeah,
than for
probably.
your POA.
Probably in today's situation.
Okay,
And
got it.
again, under the medical power of attorney, guess I should back up for a second and say you're going to name somebody to act for you. Most often that's going to be maybe your spouse, maybe an adult child, other family member. Doesn't have to be a relative. It's just someone you're comfortable with that that you want to name to act on your behalf, and then you can put as many backups in there as you want. And so when you create that document, you're going to have someone then who can take over making medical decisions for you if, for whatever reason, you can't communicate to a physician.
Got it. Okay.
So, for example, you're in an auto accident and you're unconscious, or you have a serious illness and you're on so much medication that you really can't communicate well. Or let's say you had a stroke and it affected your speech. The inability to communicate is most often cognitive, but it could also, occur when people have physical issues that can also make them unable to be responsive. And you can cover everything in the medical power of attorney from routine stuff. I want this kind of care. I want this person to consent to treatment, to take care of me. Because as you know, if you've been to a doctor's office in the last few years, medical records are very highly protected. The person under the power of attorney is going to get access to information. Doctors aren't even supposed to tell anybody but the patient what's going on.
That's kind of difficult if someone is unconscious.
Right. So you need that, the power of attorney in place will have an alternate to you to step in there and take care of things. And so you've got everything in there from the routine medical care, consents to surgery, consents to treatment, admission to various healthcare facilities, all the way on up to, there is usually in these documents a section on life-sustaining care. If you're in that situation where it's hopeless and do you want to be maintained on life support? Do you not want it? Do you want it to be discontinued if there's no hope of recovery? You can put in some intent that way as well.
Got it. So many, many things can be covered in this. And one of the things that is probably weighing on people's minds as we're talking is, how do you choose that person to be your agent? And we are up against a station break, but we'll be back shortly. And then when we're on break, we will probably be chatting, and we'll come back with more wonderful information for our listeners.